Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate specialists. And as uncertified podcast co-hosts, we try to bring our audience of trial and appellate attorneys some news and insights they can use in their practice. Both Jeff and I split our time. We both do some trial court stuff and appellate court stuff. If you find this podcast helpful, please recommend it to a colleague.
And a quick announcement. Thank you. Our podcast is sponsored by CaseText. CaseText is a legal research tool that harnesses AI and a lightning-fast interface to help lawyers find case authority fast. I've been a subscriber since 2019. I highly endorse CaseText. Listeners of the podcast will receive a 25% lifetime discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
Now, Jeff, I wanted to share a personal experience from having done this podcast with you for the last couple of years. You've joked with me, Jeff, that you had to work hard to get me to relax enough to do this podcast in the first place. And you like to remind me how heavily scripted were our first few episodes, which we now refer to as the Rudder Guide in podcast form. And now I wonder if I've gone too far in the other direction, freely offering my unvarnished criticisms of our state's no citation rule, for example, and how the jurisdictional, and I put jurisdictional in scare quotes, the jurisdictional appellate rules sometimes seem to be relaxed when the court is minded to reach the merits, and the unpredictable results that occur because of our judiciary's lack of horizontal stare decisis. And the unexpected side effect of getting up on a soapbox on this podcast is that it puts us in a club of other soapbox attorneys in other jurisdictions. For example, when I complain that our appellate courts sometimes summarily affirm, did you know that in Florida, for example, appellants have no right to a written opinion at all on an affirmance? And in jurisdictions that nominally allow you to, that's right. And even in jurisdictions that nominally allow you to cite unpublished opinions, the panel will often treat you a bit rough if you try it. So maybe it's better just to have a rule not to cite it at all. Don't even try. So we thought that we would start a conversation with a couple of attorneys on their own soapbox in Chicago, Illinois, and compare notes about civil and appellate practice in our respective jurisdictions. Today, we welcome to the show the proprietors of the Podium and Panel Podcast in Chicago, Dan Cotter and Pat Eckler. Dan Cotter is counsel to insurance companies and other financial institutions, IT and consulting companies, and nonprofits. He's been the chief privacy officer of several companies and law firms, and he has extensive experience as an in-house counsel. Dan has handled many complex insurance and regulatory issues and transactions, as well as reorganizations of holding company systems. He's also worked on privacy and cybersecurity issues for over 25 years. Donald Patrick Eckler focuses his civil practice on defending lawyers, accountants, insurance brokers, and other professionals in civil disputes in state and federal courts across Illinois and Indiana. His practice ranges from representing insurers in coverage disputes to defending professionals, businesses, and tort defendants in complex litigation. Pat's commercial litigation experience involves complex contract disputes and class action lawsuits. And drawing on his experience as a college basketball coach, Pat has also represented a coach before the NCAA Committee on Infractions. Pat is also a committee chair, columnist, and board member with both the Illinois Defense Council and the Professional Liability Defense Federation, for which he serves as a current president. He publishes extensively in professional journals on a wide range of topics, including legal ethics, attorney-client privilege, and Illinois and federal civil procedure. Dan and Pat, welcome to the podcast. Thanks for joining us.
Thank you.
Thank you for having us. I'm not the president of the PLDF anymore. My term ended, but that's okay.
Okay.
Apparently, I need to update my bio.
There you go. Now, Dan and Pat, you both practice in the Chicago area, and we've gotten connected on LinkedIn, where a lot of lawyers from a lot of different jurisdictions talk about law. How much is social media, such as LinkedIn and blogs and podcasts, shaping the law and legal culture? Is it supplementing traditional institutions like law reviews, or are they complementary? What do you think, as both of you do a lot of publishing in traditional media?
I think it's more complementary. I think, though, that one of the things that I think has been a silver lining, I guess, of COVID, that has really been the substantive and kind of more actual activity on LinkedIn. Like you said, we met on LinkedIn I see a lot more lawyers, a lot more in the insurance space, a lot more in the appellate space, a lot more in all kinds of areas of law, putting out good content and having good discussions. I don't know how much it's really impacting law in Illinois or Indiana or California, and more or less just because I don't think many of the judges, kind of like Sotomayor said the other day, or was it Kagan? We're 9 lawyers. We're probably not the best people to be doing tech stuff or anything else.
They're generalists, like all us appellate attorneys.
Yeah. And we have a generalist here, by the way, that Pat and I talk about frequently, Judge Easterbrook on the 7th Circuit. If you ever get a chance to listen to an argument where there's an acronym, listen in. He just rides the counsel repeatedly for using acronyms, and he always says that we're generalists. Maybe you know what you're talking about, but please do not cite.
Break those acronyms with a hammer, just smash them.
He says he calls them initialisms, and he says please use English words. So someone will say an acronym, he doesn't know what it is, or it claims not to. I doubt it. There's no way he doesn't know in many of these cases. And he says, "What was that? English words, please, counsel." Yeah. We're generalists, and off he goes. And then they can't stop doing it. And he just throws his hands up. I mean, you can just he gets utterly frustrated with it because they can't stop doing it. And it's pretty funny. Just call it the act. We know what you're talking about.
Yeah, there you go.
No, to answer your question,
they're so ugly. The acronyms are so ugly.
They are. And to answer your question, I agree with Dan. It's complementary. It really gives you an opportunity, though, to ferret out an idea, to get input from people who wouldn't otherwise be able to chime in on it. Have the opportunity to discuss an issue, whether they're in your state or across the country, like you all. I mean, sometimes I'll post something on an issue of appellate procedure or a procedure we do here in Indiana or Illinois, and I'll say, "Hey, what do they do in your state?" Because it's interesting to compare and contrast, because most states have got similar procedures in one way or another, but it's where those fine lines are, and that can teach you about your procedure. Oh, that's interesting. Maybe we can do that in some other different way, or you never know how it's going to shake out. I do a fair amount of insurance coverage, and clients will say, "What do you think is this covered?" I say, "I don't know. I got to look at the policy. I don't know. I got to look at the rule." And you read the rule, in light of the facts that are in front of you, and you end up with an entirely different reading that you didn't have before, because you took these facts and applied it to these words, and you went, "Oh, okay, maybe we can do something like that."
Yeah. Now, you're both active in publishing legal commentary. So in addition to your work in doing the Podium and Panel Podcast, which you started back in January 2021, is the Podium and Panel Podcast an extension of the conversations that you're having in your published writing, or is it, or are you having you're talking about different things?
Many times there's overlap. Dan's column in the Chicago Daily Law Bulletin. We both have weekly columns in the Chicago Daily Law Bulletin, which is a venerable publication that is read by all Chicago lawyers worth their salt. Dan and I are both lucky enough to have spaces there. Dan publishes on Mondays and writes a lot about the Supreme Court in particular. And then I write a column that's now on Thursdays, and I focus on civil practice issues from a defense perspective. And so many times we will refer to cases that we talked about on the show. If it's
that's double billing.
It's called being efficient. And then we have a segment of our show called the Rule of the Week, which may be a topic in one of our columns, depending upon the issue. I think our Rule of the Week this past week was my column that got published yesterday on peer review. And so, it gives us an opportunity to cross-market. It's not only double billing, it's cross-marketing. So in the LinkedIn post, it says, "Hey, if you want to learn more about this, see this podcast where he and I talked about it," or we'll say that, we're going to talk about this more on the episode upcoming. And it allows us to to get people to listen to back episodes and increase the listener count.
Yeah, that's a great idea. Wow, Tim, we should steal that. Make a note, steal that Rule of the Week podcast.
You can steal it. We don't have any protection.
We do have a trademark on predictions sure to go wrong.
We do,
but not on Rule of the Week.
And a patent on our algorithm system that's the impeccable black box that favors wins, but we've got a number of losses somehow.
It's not. It was developed by the same German scientist that developed the black box that gives higher bonuses and raises to the equity partners, as opposed to the income partners. It's that same. It's amazing. We got to take advantage of it this time. The German scientist helped us, as opposed to helping the other guys. So it was good.
So let me ask you, in addition to LinkedIn and the podcast, have you two played around at all with either Twitter Spaces or Clubhouse? You know, that kind of live audio format. Have you guys played around with that at all?
We have not, in terms of the show itself. And I'm on Twitter, but I've not really used the live feature. And Clubhouse is interesting because it seemed to spike for a while in the second half of 2022.
Yeah.
And then I don't see anybody clubhousing or whatever it would be called, or not much. They're still out there. And I listened to some stuff on Clubhouse, and to me it was kind of almost like just going to a campus of a college and people in different lounges and different fraternities, sororities, or dorms, and just chatting about whatever. And some of the speakers sometimes were actually prepared and she had something, and other times I'm like, why the hell did I just waste 20 minutes listening to somebody talk about something?
Yeah, I haven't spent it. I think I've listened to one thing on Clubhouse. I didn't do it for me. Twitter, I was on years ago, and it was bad for my mental health. So I haven't been on it, and it was just, it's very effective of sucking you in and getting you to say things you regret. And I just like, this is when it was 140, not 280 characters. And I was just like, you know what, I'm done. And so no.
Yeah. Well, if you come back, you'll recognize it as under Elon Musk. Not much has really changed in terms of, it's still muck. But all the people that we're going to go to Mastodon or other platforms, none of it panned out because they found, I think, that those were even harder to navigate or get connections on. So still,
that's right.
Well, in a minute, we're going to compare notes and talk about differences between, Illinois State Court and California State Court. But since you are both in Illinois, which is in the Seventh Circuit, Federal Circuit, let me ask you both, would you rather be in state court in Illinois or in the Seventh Circuit? I know, Pat, you do a lot of litigation. Dan, you counsel a lot of companies, and so you may be called upon to have a preference for one or the other. Do either of you have a preference, and why?
Can I give the lawyer answer?
No.
It depends.
Give the real answer.
The answer is it depends. You tell me what kind of case it is, where in Illinois State Court I'm going to be, and that'll tell me which appellate court I'm going to get. Unless what happened a couple weeks ago happens to you, and the Supreme Court of Illinois transferred a tranche of cases out of the 4th District, which is a insurer and defense friendly appellate court, and transferred them out to districts unknown for reasons not published, for a number of cases not made public, at least that I have seen. And I can imagine, and this follows on, we used to have a very easy way to figure out which courts were, or which counties were in which appellate districts. They gerrymandered the districts in Illinois in order to ensure a Democrat supermajority on the Illinois Supreme Court, which they got. And they rejiggered these districts such that one looks like a C. The 5th District now looks all kinds of goofy, and it encompasses nearly half the counties in the state. And it completely scrambled all of the districts except for Cook County, which is its own appellate district. This
has to do with the appellate districts in Illinois have to do with the composition of the Supreme Court.
In Illinois, there are 5 appellate districts. We have 1 appellate court, but 5 districts. Each of the 1st district, which is Cook County, has 3 members of the Supreme Court. Each of the other districts have 1 member appellate court. So Cook County represents about 40% of the population of the state. So it gets about 40% of the population of the Supreme Court. And then the other districts are spread, and the people who live in those districts elect a member of the Supreme Court, and then that person is subject to retention. And if they aren't retained, which happened for the first time in decades in 2020, then the Supreme Court appoints someone to fill the term until the next election could be held 2 years hence, and then there was an open seat election for that seat in that newly constituted district. That's
interesting. I had not even thought of that, because that's not the case in California. The governor can nominate California Supreme Court seats from anywhere in the state, not limited to any district. And so, frankly, I don't even know where any given one of our Supreme Court justices hail from. Do you, Jeff?
No, I've heard of gerrymandering in the political context, but never heard a story about it in the context of judges and justices.
Yeah, it's pretty crazy.
Leave it to Chicago.
I will say this, is that the Supreme Court of Illinois under the Constitution is, except for the composition of the districts, is essentially entirely independent of the other political branches. I say other political branches because you can't hardly call them non-political considering they're elected. But they don't have to go. They've got supreme power over anything that occurs with regards to courts. For example, lawyers are regulated by an agency of the Supreme Court, not by the Illinois Department of Financial and Professional Regulation, like nearly every other professional in the state.
So when it came time for the COVID shutdown and everything, that was dictated by the Supreme Court, not the legislature?
With regards to courts, yes. Yeah. But everything else was run by the governor through our, what's the name of the act? The Emergencies Act or something that he has vested with a great deal of power. But no, with regards to court closures, and the Supreme Court has issued rules. They issued emergency rules for depositions. They issued rules with regards to, they said no remote jury trials of any kind. They allowed, even if the parties agreed in the criminal context, you weren't allowed to have them.
Right.
Now in Illinois, do you still have remote jury trials, or is it back to in person?
No, we're in person. There have not been there was one. I'm aware of one remote jury trial. It was tried up in Lake County by a friend of ours, Tony Ellman, and a lawyer from Allstate. They tried it, but that I'm unaware of any other one where that's occurred.
And that is decided by the Illinois Supreme Court, whether the jury trials are going to be remote or in person.
Yeah.
Okay, because
they have complete authority over that.
Yeah, we've talked about that here. Jeff and I talked about a case that mentioned that the statutory authorization to hold remote jury trials is set to sunset, I think, on July 1st of this year. So unless the legislature acts, then the courts have no say in it. They will have to they'll have to go back to in-person jury trials, even if it's more convenient or whatever reason, or even if there's another flare-up of COVID cases. And that gets to another interesting question that I stumbled upon. I never realized this, that California is in a minority of jurisdictions where the rules of civil procedure are dictated by the legislature rather than the courts. So we follow the federal model where Congress
what could go wrong?
Congress enacts the federal rules of civil procedure.
You have no idea. Dan, please explain what we do in Illinois, because you're going to love this.
You go ahead, Pat.
Okay. So, yes, we have a code of civil procedure. We also have Supreme Court rules.
Code of civil procedure is enacted by your legislature?
They both are the same. They both have the force of law. They sometimes conflict. There is so, for example, there's a current bill in the Supreme Court rule it's the IME rule. Supreme Court Rule 215 governs independent medical exams. It says the court has its discretion to set the conditions for an independent medical exam. Fine. Illinois Code of Civil Procedure, Section 735 ILCS 5/2-1003 orders that a person can be present for the IME. And now the plaintiff's bar has sponsored a bill that allows it to be recorded, videotaped. The Supreme Court says the trial judge gets to decide this in their discretion. And so you have a conflict between the two. And I mentioned the separation of powers issue at the beginning. I think that between the two, the Supreme Court rule controls, because it's an issue of justice. So it's the wrong branch. But yeah, we have two sources of law. So for example, venue is in the Code of Civil Procedure.
Which is enacted by the legislature?
By the legislature.
Okay.
Forum nonconvenience is in the Supreme Court rules. Appeal of a denial or grant of one of those is in the Supreme Court rules under the appellate rules.
And what are you to assume that they occupy the same stature, or does when they're in conflict, does one override the other consistently, or
there are very many?
As Pat said, I mean, the Supreme Court rules should govern because it's specific to justice, but there's disputes and people challenge these in court, and it's a mess. And one of the things that's bad in Illinois, probably in many states, is Pat and I've talked about on the show. In some cases, there's all kinds of rules in Illinois about the three readings of the law. But what happens in Illinois? So the unique thing in Illinois, including with civil procedure things that happen and prejudgment interest that happened a year or two ago in the 11th hour, is a lot of times what legislators do in Springfield is they introduce a shell bill, and it may be in the health code or something else, education, and then what happens is they read that bill, and then they strip it at the end, and then they fill it with something different. It could be insurance law, it could be civil procedure, it could be anything, and then the legislature argues that they did the three readings and that the thing was debated, and then it goes up to the Illinois Supreme Court because, again, it's in our Constitution, the process. It's a real mess. And like I mentioned, one of the things that happened a year or so ago was prejudgment interest that came into that the legislature put into being, and again, it gets challenged right away. We just by referendum or by ballot initiative did a Safety Act with cash bail. That's being challenged, and the Supreme Court's agreed to hear that case in terms of whether there's going to be cash bail in our criminal justice system. So it gets to be a mess because, like Pat said, some stuff's housed in civil procedure. Sometimes there's an equivalent thing in the Supreme Court rules. Sometimes they conflict. Sometimes it's not clear what either one is really saying, and so it's
So let me put some meat on the bone with what Dan mentioned with shell bills. There is a shell bill for every section of the Illinois combined statutes, so that at any time the leaders can pull a bill because it has to meet a germaneness requirement under the Constitution, under Article 2, Section 8 of the Constitution. It has to meet a germaneness requirement. So they have every section of the code has a shell bill. And by a shell bill, it takes a definite article and makes it an indefinite article. And that's a bill.
Okay.
So we can change any section of the code we need to change at any time.
This is kind of how the House will send up a tax and spend bill to the Senate, and they'll just put it on the shelf until they want to start their own bill because the Senate doesn't have taxing authority. But if they got a taxing bill from the House, then they can say
that the bill began in the they can say that the bill began in the House. Yes, right. even though it began in the Senate.
Right.
It's the same kind of shenanigans, and what there is the Senate president and the Speaker of the House have to certify that they follow the rules. And Illinois has adopted what's called the enrolled bill doctrine, which means different things in different states, I've learned. But in Illinois, it means that so long as the Senate president and the Speaker of the House have signed off that they followed the procedure, and the Supreme Court isn't going to challenge it. Now, there have been multiple challenges to this, as Dan elucidates, on a variety of issues. And the Supreme Court hasn't, its most recent opportunity, the case settled right before it was going to get decided. But they have two cases. They've got the prejudgment interest case making its way up. They've got the Safety Act, and they've got the new assault weapon ban case that's going to go up that's got the same issue. Every one of these things. The prejudgment interest bill and the first bill in the Safety Act passed at the same time at 3 a.m. in the morning at the very end of a lame duck session. January 13th, 2021 is going to go down and may go down in the annals of history as a very bad hour for the Illinois General Assembly if those two bills get struck down because they didn't follow the Constitution.
And one other thing you should know about right now in Illinois is not only the Supreme Court is a supermajority, but both the House and Senate are supermajority Democrats, and it's been that way for a couple of years now. At one point, they were kind of split, and they were closer, but through gerrymandering and other efforts, it's become more and more a democratically majority body. And so these things that Pat talks about, these sign-offs, again, you can't question them, but a lot of times you look at the kind of legislative history and the record, and it's like, it's woefully inadequate. But
so you mentioned that in Illinois, there's a Code of Civil Procedure, and then there's, what is it called, the Supreme Court rules. Rules of it's similar to in California. We have California Code of Civil Procedure, and then we also have the California Rules of Court, which is promulgated by the Judicial Council. But there's a definite hierarchy there, that the rules of court are not allowed to conflict. They can only supplement or fill gaps in the Code of Civil Procedure. And a famous contest that is still relevant today between the Code of Civil Procedure and the Rules of Court concerned the use of court reporters, or alternatives to court reporters, rather, electronic recording system. Back in the 90s, they rolled out this pilot program, installed equipment in a few different county superior courts to test out whether we can electronically record the proceedings and have them transcribed later on for use as an appellate record. And it seemed to work out okay, maybe even arguably a cost savings. But the court reporter lobby has amazing influence in Sacramento, and they quashed bill after bill after bill. And so today you cannot use any method for creating an appellate transcript except the court reporter. There's two other methods that Jeff and I kind of joke about because they are so rarely successfully implemented. Settled statement and agreed statements basically have to come up with a summary of what happened at the proceedings afterward.
We have Supreme Court Rule 23, what we call a bystander's report.
Yeah, sounds like the same kind of thing.
Yeah.
And so the legislature, there was a bill proposed in the 90s to allow electronic recording. It got quashed, and so now here we are. There's a national court reporter shortage, and there's not a lot anyone can do about it unless someone can stand up to the special influence and get some kind of alternative method implemented. We now all have all this. All the courts have Zoom technology or some equivalent recording technology for broadcasting its proceedings. All they would have to do is hit the record button. But there is a Code of Civil Procedure right on point that says you may not hit the record button even for judicial note-taking purposes, and certainly not for creating an official or unofficial appellate record. So.
Interesting.
And a rule of court, just to close the circle on this one, there was a rule of court that allowed the courts to raise funds and to spend funds on an electronic recording system, and the Court of Appeal found it invalid because it conflicted with the Code of Civil Procedure.
It's interesting that a few within the last month, Pat and I, as a rule of the week, we talked about an Indiana proposed change that had to do with electronic recording of hearings and getting rid of court reporters, and we don't know where it's still in its infancy, but it's interesting. And Pat and I, when we talked on the podcast, as I mentioned before, he was able to join us. When we record our weekly podcast, we often have audio issues, and so we just marveled at some of that. The minute and a half of excess, dead air, things cut off. We have to get back in and back out. We have to do some surgery to the thing. So just interesting that, maybe that's where Indiana got it from, because it's not really clear.
Yeah. No, I'm convinced that the simultaneous court reporter transcript is the gold standard. There's not going to be anything that's better than that. but there are a lot of litigants, particularly indigent litigants. A lot of family law practitioners and probate practitioners have been kind of spoiled because they were the last holdouts. Those departments in California were still provided with court reporters, as a matter of course, for years. Jeff and I, in our civil matters, were had to bring our own court reporters, but now, because of the shortage, even family law and probate law attorneys need to bring their own court reporters. In Illinois, do you have to bring court reporters? Are they provided for, or are there alternatives to court reporters to creating an appellate record?
So a couple things. If you're in one of the 16 calendars of the Chancery Division of the Circuit Court of Cook County, the chief judge, that judge has a court reporter.
Oh,
that is the only civil judge that I am aware of that has an assigned court reporter. Obviously, at 26th and Cal, which is the primary criminal courthouse in Cook County, there are court reporters in the criminal courthouse. But no other civil court am I aware of in Illinois of any variety has court reporting. Now, there is recording in many of the smaller jurisdictions, and certainly in DuPage County, which is the second largest county in Illinois, just the county just to the east of, or just to the west of Cook County. In Kane County, which is just to the west of that, they have recording. But the principal civil courthouse in Cook County, you could not wire for recording. They can't even wire it for internet. The Daly Center, they can't wire for internet because if they did, they would have to shut the building down because of all the asbestos.
Oh, you're kidding.
So they can't disturb it. So they can't wire the thing for internet. So they surely can't wire it for recording. So that's off the menu. The problem with the recording situation is in not having a court reporter. I wrote about this in my column, all of the problems of how a trial would be different if you don't have a court reporter that can go into chambers, that can go to the sidebar, that can go and allow for the individual voir dire of a venire person who has got some sensitive issues they need to talk about. Let's suppose they've got a personal reason why they can't be at the trial, or they have a health issue, or that perhaps there's the nature of the case requires an inquiry into sexual abuse or things, and who knows what kind of questioning. But you can't do that without having the entire jury do calisthenics up and down, out the jury room, into the courtroom, because you've only got recording in one place. You've got to be, and how do you do a readback with a recording device? You ask the perfect question, the witness goes, "Can you repeat that?" How do you do a readback? What happens if the recording device doesn't record?
No, yeah, that was one of the big problems. One of the complaints that were common when they had the pilot program in California in the 90s is a lot of judges wrote in to the legislature and said, "I don't like these recording systems because every time an attorney asks, 'Can you read that back?' I have to." When they didn't have special people there monitoring and running the recording system, and it was all on tape, so the judge had to reach over, hit the stop button, rewind, find the place in the tape, hit record again when it was done.
And how do you do daily copy? You can't do daily copy without having a team of 2 court reporters, one in the morning, one in the afternoon. So you get the morning report by 4 or 5 in the afternoon, and you get the evening one, the afternoon by 7 or 8 at night.
Right. You have to treat the proceedings as generally as though there is no court reporter there. You just have the peace of mind that, well, if I do need to appeal, then I can turn that recording into a transcript somehow.
Yeah, court reporters are not only invaluable for the preservation of the record, but they are invaluable for the trial, the functioning of the trial itself. And in the absence of them, you have got a real problem. The answer to the shortage that I know is acute in California and certainly exists here as well is not to get rid of court reporters. It's to train more of them. And we've got to find a way as a profession to do that.
Well, that's been the problem. And for 30 years, they've been losing uptake in that profession. It's hard to imagine why. It's not like it's not a well remunerated profession or interesting profession. It is a difficult profession. I've looked at the stats for the number of people who test. They have to take something. They have to take a dexterity exam and a certain number of words a minute, and a very, very small percentage. I think it was like less than a third of the people who test for this exam pass it in California.
It's expensive.
I think it's similar to a nationwide.
It's expensive to test for it too. The equipment costs, I've been told, upwards of $20,000, along with the education and the time it takes. But they are very well paid. Also, you want to talk about a flexible job, work when you want to for a working mother. What a great job. You can work anytime.
But it's the same with shorthand, and that's part of the skills. And my mother-in-law did shorthand back in the day, and that's a lost art as well.
Yeah.
And,
So it sounds like we have similar struggles on the court reporter front. Yeah. Let's hit some other procedural issues. I wanted to ask you about starting.
Can we go back real quick on more crazy civil procedure stuff? So who writes your pattern jury instructions in California?
We have two of them. We have KC, CACI, and BAJI. BAJI. I don't know who the institutions are.
It's the Judicial Council, isn't it, Tim? Isn't the Judicial Council?
Judicial Council? I don't know the other one.
Do they represent the law of California?
The Judicial Council writes the rules of court. So they are, and it is a. I should know they are an arm. I think the head of the Judicial Council is the Chief Justice of the Supreme Court.
So in Illinois, the Illinois pattern jury instructions are written by the IPI committee. It's a committee appointed by the Supreme Court. Unlike the Supreme Court rules, the IPIs do not have to be approved by the Supreme Court. And it is not infrequent that the IPIs get struck down.
Huh.
Yeah.
Yet, under Supreme Court Rule 239, you must use the IPIs, even if you don't think that they represent the law. So what you end up having to do, you have to tender an alternative instruction. The judge won't give it because they can't. And you preserve the issue. And then if you're right and the instruction gets struck down, then you get the privilege of trying the case again. And that's going to become a big issue because we recently had the IPI committee, which is controlled by the plaintiff's bar, eliminate a version of our proximate cause instruction that clearly represented the law of Illinois as stated by the Illinois Supreme Court. They got rid of it. And so that's a coming issue in the future. It's a mess.
There used to be special instructions, and those are eliminated as well. So yeah, it's a constant. And I don't try a lot of cases, but the last time I did, it takes days because you go through all these instructions, even though, like Pat said, you got to use them because you argue over there's alternative language sometimes, bracketed language, and then sometimes you're arguing that it's just wrong, like Pat said, because it's not consistent with what actual law is, what the courts have actually decided.
Here in sunny California, we have form instructions and we have special instructions you can propose. Are you telling me that your state no longer has special instructions?
So special interrogatories. So you can have a non-pattern IPI. The judge can either take it or leave it. They have to give an IPI if it fits the case. If the facts and the law fit, they have to give the IPI. If you have a non-standard instruction, they can take it or leave it. Special interrogatories were used as to test an element of the claim because under Illinois law, under the Code of Civil Procedure, we only give general verdicts. We don't give special verdicts. So if you want to add, and by that I mean our issues instruction folds all of the elements into one instruction. They don't get asked duty, breach, causation, damage. They get asked, do you find in favor of whom and for how much? Right. Yeah. It's one form.
A general verdict. You saying you cannot, or the judge cannot give a jury a special verdict form?
Special verdict forms are not allowed. So you can get special. We used to be able to get special interrogatories, and I testify. So this actually is a creature. of the Code of Civil Procedure, Section 1008 of the Code of Civil Procedure, and what it said is that under the old rule, the instruction, if it was offered, had to be given, and if it contradicted the general verdict, it controlled. So you had multiple circumstances where the jury, it happened a lot in police brutality cases, police shooting cases. They found in favor of the plaintiff, and then they asked the question: was the police officer at the time of the shooting acting in defense of himself or others, reasonably in fear for his life or that of others? And they would answer the question, yes. No verdict, 0, after giving $1 million verdict. And the jurors were like, well, we didn't understand. So, well, that means you didn't understand the issues instruction, because there was obviously an affirmative defense of self-defense or defense of others. You plainly didn't understand the causation instruction. You didn't understand the issues instruction, but you understood the very simple question. So the person who I was testifying against was a fellow named who's now, he's on the Supreme Court Rules Committee. At that time, he was president of the Illinois Trial Lawyers Association, Larry Rogers Jr. And Larry had one of these cases, or at least one of these cases, maybe 2. And Larry and I testified against each other, both in the House and the Senate, on this topic. And we now have this goofy rule where they don't have to give the instruction. And if they do give the instruction, it doesn't control. So basically, it's useless.
Well, most of the exercise of reading jury instructions is useless anyway. We've talked about this. It serves mostly a ceremonial function so that we can tell ourselves in good faith that the jury was instructed on what the correct law was. Sure, it went 100 feet over their heads, but
no fault of their own. So yeah, no, it's a very goofy situation we have, and I was deeply involved in the special interrogatory fight several years ago. And we actually have had Larry on the show talking about a shooting case that he handled, that he would argue it in the 7th Circuit. And it's funny, the first time we were going to have him on the show, the opinion came down as we were beginning to record.
Right.
We were going to talk about the oral argument, and it came down. So we had to reschedule once the opinion came down. And but yeah, he came on the show about a case of tragic situation in West Suburban County. He's great, but it's an issue we don't agree on.
He's a bit suspicious as well. I think I would say about coming on the show, because he thought that we were going to take some angle. But again, our podcast is not taking angle. It's really to kind of get out cases of interest to the public. So.
Well, I'm still reeling at the prospect of not being able to have a special verdict form. My first instinct, I don't know about you, Jeff, is I would want to go in on a motion for new trial and at least try to get something on the record about where the fulcrum point was in the trial. Because if you just get a verdict form that says thumbs up or thumbs down, you have no indication of where.
Welcome to Illinois.
Yeah,
the last case I tried was a shooting case under the old rules. And it was a third-party criminal act case. I represented a bar, and we offered 12 special interrogatories. She rejected every one of them. The judge did. We offered multiple alternative pattern and revised instructions, non-pattern instructions, trying to get something in front of the jury about the criminal is the guy who shot the plaintiff. Fortunately, plaintiff didn't die, but of course he did it in a cop bar. And the cop, so the shooter, the guy who shot the plaintiff, he gets killed by the cops who were in the bar, because there were 6 cops in the bar.
Okay. Wow. Well, I wanted to get to some other procedural curiosities here to try to compare and contrast here. Let's talk about stare decisis. I mentioned earlier that in California we have no horizontal stare decisis. So we have how many? We have 6 district court of appeal in California, and an opinion of any one of them is not binding on any of the others. In fact, the opinion of the 4th District Court of Appeal is not binding on what it's going to do today. So that's right. So there's it's kind of ollie oxen free. There's no precedential value basically.
Very similar here.
Tell them what happened with Justice Steigman the other day in the 4th District. Dan, we talked about it where the guy said it was a case that started out in the 2nd district.
Right.
It was one of the so tell what Justice Steigman had to say.
This is one of the ones that the Illinois Supreme Court.
No, this was part of the gerrymander. This was not part of the Senate. Yeah, this is part of the gerrymander.
This is part of the gerrymander. Yeah, and not bound by 4th or 2nd. So it's just a mess. And as we mentioned earlier, the 1st district has, I think, 5 or 6 panels. Six. And so even there, and they rotate every so often so that there's not the same 4. Three are on any panel at a given time. And so in the 1st district, again, because there's 6 divisions, there is even, you can be in the same division on the same issue, but because it's 3 different panelists and because they rotate, there's no binding effect at all. And even though, as Pat said, we have this theory and the thing that we have one appellate court, but unlike Indiana, which only has one Indiana appellate court because of the size of the state, here we have a very different monster. So
in Illinois, is one district's opinions? Do they follow their own opinions? They, as a matter of course, maybe they do, or matter of practice, maybe they do, but they're not bound to. No,
they're not bound to.
Is bound to follow its own opinions or any other district's opinions.
That's right. So give an example. Another one that's close to my heart because I won it on appeal. It was the statute of limitations for spoliation claims. So the 1st district was split on what the statute of limitations was, said it was 5 years. The 2nd district said it was 2 years. And I'm sorry, the 3rd district said it was 2 years. So that meant the court I was in the 2nd district, which means he gets to choose. If the 2nd district had spoken on the issue, then he was bound by what the 2nd district said. If he's in the 2nd district and only the 1st district has spoken to it, he's bound by it as a trial judge. But if he's in the 2nd district, the 1st district said A and the 3rd district said B, he gets to choose which one he likes.
Okay.
Or he can choose C if C's on the menu. But
the trial judge bound by the judicial opinions in his or her own district
if they've spoken to it,
okay.
Or they're bound by any of the appellate courts if they've spoken to it. But if there's a conflict, they're bound by the one in which they sit. And if there's a conflict and it's not one of the courts in other districts in which they sit, they get to choose.
Yeah, that's something that's different here in California because you are not bound. A trial judge is not bound by the appellate decisions of its own district. You can follow any other district.
Oh. Okay, that's interesting.
You would think there would be some sort of loyalty to your own district, but no, it's not so.
Okay, no, I mean, your system is not unlike the fact that the appellate court is not bound by its own decisions is no different than the federal system. I mean, a federal district judge isn't bound by his own rulings. He's bound by the Supreme Court. He's bound by the circuit court in which he sits, but he can do pretty much what he wants otherwise, and the circuit court isn't bound by anything but the Supreme Court. They can do whatever they want. They don't have to pay attention to what some other circuit court did.
The panels of the Ninth Circuit are bound by Ninth Circuit precedent. So they do have horizontal stare decisis.
No, that they have that in the Seventh Circuit in their own, of course, but they can only be overturned by an en banc panel if we're going to change our mind, which they did in the Ivey decision, which dealt with discrimination based upon sexual orientation in the Seventh Circuit.
Okay, so we have a similar situation in terms of no horizontal stare decisis in Illinois or in California. Let's talk about unpublished opinions. So in California, we cannot cite to an unpublished opinion in our state court system. Not just that they have no precedential value, you may not even mention them. Technically, not even to show. Technically, even if you're filing a petition for review in the Supreme Court, you're not even allowed to show that there is a split of opinions, a split of decision when one side of that split is made up of unpublished opinions. But it's routinely done anyway, and the Supreme Court has never admonished anyone. It's apparently a tacit blessing on that practice. How does it work in the Illinois state system?
Not that simple.
Not even that simple, huh?
No. So in Illinois, we had unpublished opinions were created because there were too many cases And so it cost too much to bind all the cases. So what they did is the Supreme Court had an order that gave a certain allotment of published opinions to each of the appellate districts. And that went on for about 10 years. And so the appellate courts had to decide. What's that?
They have an allotment?
They had an allotment for about 10 years.
Is it number of opinions or number of pages?
No, the number of opinions that they were allowed to publish. And that went on from like the early 90s to the mid-aughts. And then they kept the rule even after in the late aughts when we adopted an entirely electronic system and stopped binding them. We still kept unpublished opinions. And basically unpublished opinions turned into the flotsam and jetsam of Illinois jurisprudence. And, this is where we're going to put all the stuff. And so there's been a long, and at that time you could not cite them for any purpose, for any reason. Nobody's allowed to use them. There were stories of justices at oral argument ripping up the briefs of an advocate who had cited an appellate. There you have stories of this, just ripping up the brief.
Right, admonished in front of for doing it.
Wow. Rip up the brief.
The judge is ripping up the brief.
Yeah.
In open court.
So So don't do it. So then there was a long, and so I had been a very loud advocate of getting rid of this rule, but only because of the flotsam and jetsam, only prospectively, not retrospectively. The Supreme Court Rules Committee wrote it to be able to use all of the unpublished opinions. And to do justice to their argument, the argument was that a judge can cite to music lyrics, poetry, books, but he can't cite to an unpublished opinion.
They could cite to this podcast.
Like to this podcast if he'd like to. I don't know why he would do that, but he could. So that was their argument. The Supreme Court changed it and said it was only opinions that were issued after January 1, 2021 are allowed to be cited for persuasive authority only. They are not binding. We still have a process of getting opinions published. So if opinion is unpublished, you can file a motion asking for it to be published, and generally that's granted. So we still have that process of opinions. That do you have a process of allowing unpublished opinions to get published upon request of one of the parties?
Yeah, within 15 days.
Or a non-party, such as
I've heard that too. Yeah, a non-party can ask for it.
Yeah.
And now in Illinois, what happens is when you do that, you then extend the time to file a petition for leave to appeal to the Supreme Court. So if an opinion is published, then the 35 days to file your PLA restarts.
Yeah.
So there's that.
Yeah, that happens here as well. So you have 15 days to file that request to get it to make it published.
But does it restart the time to file the PLA or whatever mechanism to get to the Supreme Court?
Petition for review. It does restart the time here.
Right.
Yeah, it's 30 days before it becomes final in the Court of Appeal, and then the baton gets handed up to the California Supreme Court. All right, now let's talk about written opinions. Now, I was recently talking with Lindsay Lawton, another LinkedIn appellate attorney, and she pointed out to me that in Florida, they have no right to a written opinion when the Court of Appeal is affirming. So they get a lot of the affirmances are summary affirmances, just one page. Judgment is affirmed. Have a nice day. In California, we have a constitutional right to a written opinion on appeal. And after talking with Lindsay, I was very grateful for that constitutional provision. Do you have that in Illinois? Do you have a right to a written opinion?
I think you get it. I don't think you have I've never seen it not done.
Right.
What you have in Illinois is Supreme Court Rule 352 that you're entitled to oral argument unless the court says it doesn't need it, and then it then has to explain why. Now, the appellate court almost as a rule doesn't do that. There's only one panel of the first district on opinions that are issued without oral argument that'll drop a footnote and say, under Supreme Court Rule 352, we say we don't need oral argument to decide this case. We don't have oral argument. There's only one panel that seems to do that with any regularity in the entirety of the state. But the Supreme Court, I can't remember which Chief Justice it was, really wanted more oral argument. and really got on some of the districts for not having it. In particular, the second district for a while very rarely would grant oral argument, and then they got the beat down, and then they started doing it more often, is my understanding. Begrudgingly, as I understand it, but yeah.
Well, then what happened with the second district now is they're in a rocket docket. So whenever we see a case of interest, Pat and I, for the podcast, we do it that Sunday because it's oftentimes Monday or Tuesday. They've issued, and sometimes they're long opinions. It's almost like they're pre-written. They're 20, 30 pages of detailed stuff that would be impossible for any clerk or justice to pop out within 2 days of oral argument. But
yeah, my last appeal in the second district that did not go as I would have liked. I knew what was going to happen. I knew they had already written it, and sure enough, less than 7 days after the oral argument, there was a 30-page opinion. So they plainly didn't write that in the week in between the date of the oral argument and the date that they issued the opinion. So
I take it you folks, you don't get tentative rulings in any of your courts or focus letters?
No. That's very. I have a case out in California with one of my partners, and they got this tentative ruling. I was like, "What the hell is this?" Tell me about that. That's wild.
Yeah. All right. Well, I've got a ton of other topics that we could touch on, but we're running short on time. So let me just ask you, Pat and Dan, are there any procedural quirks, anomalies, curiosities that you wanted to talk about that you think are really unusual in Illinois, or that are really that work really well in Illinois and ought to be adopted elsewhere? Before we move on, and I thought, I wondered if maybe it would apply in the summary judgment context. I know that's an area where you need the best trial attorney minds and appellate attorney minds kind of coming together, making sure you're preserving all issues, or post-trial motions, things like that, waivers. I know sometimes Jeff and I talk about the rigidity of rule, Federal Rule of Civil Procedure 50 A and B, which require a judgment as a motion for judgment as a matter of law to be made before the jury is charged and after, in order to preserve it for appeal, or else it's just forfeited. Any other issues we should talk about for the good of the record?
I can't imagine Illinois does anything that anyone else should adopt. I can't imagine there's such a thing. I will say that the courts have pretty well enforced Section 1202, which deals with post-trial motions. And if you don't raise it, your goose is following a jury trial. If you don't raise it in your post-trial motion, your goose is cooked on that issue. And there was a case that came down not so long ago. I wrote an amicus brief on it for the Illinois Defense Council with a former colleague of mine, Rich Berglund, on this very issue. And that's one area where I think they really have done we've got a good rule, and they've actually applied.
Yeah. That sounds similar to Rule 50A.
It does. Yes.
Yeah.
Give the trial judge an opportunity to fix the error if there was one.
Yeah.
Right.
Yeah.
They're in the best
California,
position
they're not that rigid here. There are only a couple of different kinds of issues that you have to raise in a motion for new trial, but otherwise you're free to let all your legal issues, your good legal issues, put those in your back pocket for appeal, and not give the trial judge an opportunity to fix it. Okay. What about just quickly touching on oral argument on appeal? Do the Illinois State Courts of Appeal ever give tentative opinions or focus letters? They ever tip off the attorneys what they should be ready to talk about?
Oh, they may. I mean, they don't call them that. They may send, on rare occasion, be prepared to talk about X, Y, or Z.
Yeah, that sounds like a focus letter we have here in California.
That's very, very, very rare.
Yeah, and occasionally they'll ask something to be briefed, but again, that's very rare as well.
Yeah,
something peculiar to the case.
Yeah,
it's far more common in the Seventh Circuit, where they'll write a letter to or they'll give supplemental briefing if they raise an issue, especially in the Seventh Circuit on jurisdiction, subject matter jurisdiction. If they are always questioning jurisdiction in the Seventh Circuit, so you'll oftentimes have, how the hell are we hearing this case?
So they're just dipping their toe in the water there in Illinois state courts on these what we call focus letters. There's only a couple of districts that do it here in California, but it's the reception among attorneys is universally positive. And then whenever a justice is asked, during some conference on a panel or something, they're usually for it if they have an opinion on it, and they'd say it's just a matter of getting a new generation of justices on the bench who will adopt the practice, because otherwise it's just not something that they're used to, and so they don't do it.
I kind of like it because it focuses the parties then on the topics that the justices are interested in, rather than sometimes where they just kind of, it's a free for all and not very helpful potentially.
Yeah. All right. Well, thanks, Pat and Dan, for joining us and talking about some of these curiosity, appellate, and procedural issues. Jeff, let's do a quick lightning round with Dan and Pat here.
Lightning round. Okay. This is our patented, copyrighted segment of the show. It answers the most pressing questions that vex appellate nerds around the world. Short responses, one sentences if you can, one word if you can. I know it's hard with lawyers to do that. Question number one, font preference, Century School Book, Garamond, or something else?
Times New Roman.
Yep.
Come on. We're recording.
We are.
Look how wide Jeff's eyes got.
Yeah, I will say that it is, I rarely see, there are some people that use Garamond, some that use Bookman was the one that my 13-point Bookman was one that my former colleague of mine who has 700 published opinions, that's what he would use. That's what I used on a lot of appellate briefs, because if it was good enough for Robert Chemers, it was good enough for me. But generally, my regular briefs are probably Times New Roman, which is probably sacrilege.
Tim, we got to have a litmus test for future guests. Question one. All right. Second question. I'm bracing myself.
Hey, at least I didn't say Ariel.
Yeah.
Yeah.
Yes.
Comic Sans.
Second question. Following a period, one space or two?
One, but I often straighten it when I'm writing, just by my 56-year-old brain.
Two unless I'm writing for the Illinois Defense Council Quarterly, which requires only one.
Wow. Okay.
Yeah, I'm failing all of this miserably.
You don't take a hint from that?
Yeah. Hey, I'm answering honestly. It's how you know that's how you know it's the truth.
Yeah,
I know what I'm supposed to say.
Right.
I think I know the answer to this third question, but I'm going to ask it anyway.
Ooh.
In the meat of your brief, when you have headings, argument headings, Roman numeral 1, etc., do you use all caps, sentence caps, or initial caps?
So it depends. So in the Roman numeral, so I have typically in a brief, I'll have five, in a trial court brief, it'll be 5 parts: introduction, facts, standard, those are all caps. The second level, the A, so those are Roman numerals. Yeah. The next ones, the A's are just regular sentence and bold. They're not first letter caps. It's a sentence that's bolded with a period as a complete sentence.
There you go. Correct answer.
I can live with that. I can absolutely live with that. You've redeemed yourself.
Okay. Well, yeah, we haven't got to the Oxford comma yet.
I don't have a question for that. I think the final question I'll ask is Tim's question that he likes to ask, which is pled, P-L-E-D, or pleaded, P-L-E-A-D-E-D. What's your preference?
The correct one is the latter. I read that somewhere. That's the correct one.
Yeah, it's pled.
It's
definitely not pleaded. That sounds terrible. I don't care if it's right. It sounds terrible.
Pleaded is right, though. That's the correct answer. If you look at there's actually a white paper or something out of that found one time.
Yeah, the official institution.
I'm back to that 70s song of "Loving You is right. If loving you is wrong, I don't want to be right." That's where I'm going.
The official institution that designates new irregular verbs has not made pleaded into an irregular verb. So pled is just a made up irregularity.
It's one that sounds good though.
All right.
Pleaded is very hard on the ears.
Both survived our dreaded lightning round, and we'll be sending you our patented copyrighted coffee mug as a thank you for surviving the lightning.
Appropriately edited. One
Appropriately
space,
edited.
not two in between sentences.
Yeah.
Okay, well, that's going to wrap up this episode. We want to thank our sponsor, Casetext, once again for sponsoring the podcast. When we include links each week in the show notes to our podcast, we use Casetext. Listeners of the podcast will find a 25% discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
And if you have suggestions for future episodes, please email us at info@calpodcast.com. And in our upcoming episodes, look for tips on how to lay the groundwork for an appeal when preparing for trial.
Thanks again, Dan and Pat.
Thank you.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.